Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to answer the common question that we hear a lot, which is if my accuser doesn't come in and testify at trial in a sexual assault case, will I be able to beat the case? And the answer is usually yes. But what we saw recently coming out of the state of Idaho was really, really unique. There was a state representative there, a former state representative there, who was accused of sexually assaulting, of raping an intern. I think he was in his late 30s, and the accuser, she was in her late teens. She was 19, 20 years old or so. And the case went to trial out there in late April 2022. And midway through the direct examination of the accuser, so the alleged victim, she, for lack of a better word, had a meltdown and ran off the witness stand and said, "I can't do this anymore," I think were her exact words. Was not subjected to cross-examination. So the defendant's attorney never had an opportunity to question her before she ran off the stand. So what the judge did was the judge struck her testimony and ordered the jury to not consider it as if she didn't come in at all. Well, from the defense perspective, that's really, really good, right? Because without the alleged victim, without the accuser's testimony, what is there? Well, in sexual assault cases, there sometimes can be certain things that could still get in that in this instance actually still resulted in the defendant, this former Idaho representative, being convicted of sexual assault. And me personally, I was interviewed by the Daily Beast about it, and I gave quotes along the lines of highly unlikely he's going to get convicted. And so many other experienced criminal defense attorneys shared that sentiment. But what was amazing was the jury either one, disregarded the judge's order that they can't consider what she testified to up until the point she ran out, or two, relied heavily on the testimony of her mom, of the accuser's mom, who talked about the condition she was in, the mental and physical condition she was in soon thereafter the alleged encounter with the former state representative, and as well something known as a SART, S-A-R-T is the acronym, SART nurse, who will respond and meet with a sexual assault accuser, to examine whether or not there's any injuries or whether or not there's any evidence that could be collected that could support a prosecution, support their claims. This was a consent defense by the defendant, in that something happened. Yes, they had sex. Yes, it's consistent that his DNA would be on her or found in her, but that it was consensual, that it was not forced, that it was two voluntarily individuals, of age, having sex. And the defendant actually testified in this case, even after his accuser ran off the stand and didn't testify. And the defense did not ask for a mistrial. They went forward and decided, hey, let's roll with what we have. Without her testimony, we feel real good about it. Forget about the fact that the jury may have considered what she said, even though the judge said not to. We don't want a mistrial. We don't want to do this again. Why? Because the prosecutor in all likelihood would get her back and be able to bring her to the witness stand in front of a new jury, more likely to get our client convicted. What happened was that strategy backfired for this Idaho defendant's defense team because the jury still convicted him. So really, really unique case, really, really important case as it relates to sexual assault accusers not testifying at trial, confrontation clause, that the defendant has, a criminal defendant has a right to confront and cross-examine all witnesses against him or her. Really a bedrock of our principle in criminal law in the United States, and obviously passed on to each individual state. But not always as easy as we may think in a sexual assault case. A lot of strategy still goes in play. The hope is that strategy works out well if you know what you're doing and have a plan in place. By all accounts, it looked like they were going down that path in Idaho as the defendant was concerned. It did not ultimately go the way that they thought, the way that a lot of people, myself included, thought it was going to go. So much so that, the Daily Beast published an article, I think the next day, talking about how shocking that verdict was when it came down. And not only did it come down where you have multiple, 12 people unanimously agreeing to convict beyond any and all reasonable doubt, it came down within a short amount of time with only just a couple of hours of deliberation. So if you find yourself accused of sexual assault, you find yourself going to trial on a case, you have questions about what can and cannot get into evidence, you want your case evaluated, you want to either make a change with your current attorney or bring on our firm, hopefully earlier rather than later, to get in, to start representing you the right way, give us a call, 619-295-3555. Again, lawyer, 619-295-3555.